Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I bid to Dr. Duriana and to all our fellow classmates. Today, we will be presenting question 4. My name is Masnia, and together with me, Alia Tahani and Siti Fariza. The question is, explain the procedures for admission and examine the following cases. First case, Chi Kuat Lin and Majlis Peguam 2012. Second case, Majlis Peguam Malaysia and another, and Judy Blasius 2017. This is basically the outline of our presentation today. The first part will be presented by me, Masnia, and it will be on the admission process, in which I will be focusing on section 3 until section 17 of LPA. On ad hoc, special admission and admission of foreign lawyers, this will be presented by Siti Fariza. On sigil annual and practicing certificate will be by Alia. For case review, the first case will be discussed by Alia and second case will be discussed by Siti Fariza. Now let's start with the first part of the presentation, that is on admission process. So before you go into the detail, I think one of the most important thing that we need to know is who are the person that is eligible for admission into legal profession. So in order to answer this question, we may refer to section 10 of LPA, in which section 10A mentioned about qualified person and section 10B mentioned about article clerk. In other words, under this section, there are two categories of person that is eligible for admission. So I will be dealing with section 10A first and all the requirements, and then move to section 10B with the requirements, and then later I will be discussing on admission process by looking at section 14, 15, 16 and 17 of LPA. So now, the meaning of qualified person is actually has been defined under section 3 of LPA, which includes those who has passed the final exam leading to the degree of Bachelor of Laws of the the University of Malaya in Singapore, the University of Singapore or the NUS. B is a barrister at law of England, or C is in possession of such other qualification as may by notification in the Gazette be declared by the board to be sufficient to make a person a qualified person for the purposes of this act. That is the meaning under section 3. Now, what are the requirements? We may refer to section 11, 12 and 13. Under section 11, the qualified person must be a citizen or permanent resident of Malaysia. That is number 1. Number 2, has attained the age of majority. Number 3, has good character, or in other words, has not been adjudicated bankrupt, has not been convicted of any crime, has not done any act which, if he or she are a barrister or solicitor in England, would disbar, disqualify, suspend them from practice. D, has not done any act which would disbar, disqualify, suspend he or she from legal practice in any other country. And number 4, last but not least, has completed the necessary period of pupillage. That is all under section 11. Moving on to section 12. Section 12 deals with the period of chambering. So a qualified person must undergo a period of pupillage, or we call it also chambering, of 9 months before being admitted as an advocate and solicitor. Section 13 deals with qualification for the requirements for the master. The master must be in active practice in Malaysia for not less than 7 years, immediately preceding the date of commencement of the pupillage. Also, he must possess a valid PC, a valid practicing certificate throughout the period of pupillage of his or her pupil. So that is for section 13. Another additional requirement is the Bahasa Malaysia Qualifying Examination, BMQE. So by virtue of section 5F and section 11 subsection 2 LPA, these two sections has empowers the board to conduct the BMQE. There is exemption to those who obtain a credit in SPM for Bahasa Malaysia or any other equivalent examination such as SCPM. So during the exam, there will be an oral test on the proficiency in Bahasa Malaysia, and the fee for this exam is 100 ringgit. So that is all for the requirement under the qualified person. Now let's move to the second category, that is article clerk. The provision for article clerk can be found in section 20 until section 25 of LPA. The meaning of article clerk is basically a person who has entered into articles or service agreement with an advocate and solicitor. An advocate and solicitor who takes an article clerk is known as principal. So the requirement is number 1, 17 years of age. Number 2 is of good character. And number 3 satisfies the educational qualification prescribed by the LPQB. With regards to the differences between QP and SC, we can see that in terms of academic qualification, qualified person are those who graduating from law school, while article clerk are article clerk might be graduates with no law degrees or non-graduates with 6 credit SPM. In terms of period of pupillage, qualified person will have to undergo pupillage for 9 or 12 months, while articleship lasts either up to 3 or 5 years, which is much longer compared to the pupillage. So now let's discuss on the legal requirements, and I will start with section 15 on petition for admission with affidavit. I have listed down the gist of this section, in which number 1, any application for admission must be in form of petition to the court and must be verified by affidavit. Number 2, there will be particulars that need to be exhibited within 14 days after petition. What are those? Number 1, true copies of any documentary evidence showing that he is a qualified person. Number 2, two recent certificates as to his good character. Number 3, a certificate of diligence from his master. Number 4, a certificate signed by secretary of the board that the petitioner has attended the courses of instruction and passed the examination if any required in his case under the Act. Number 5, a certificate from his principal that he has satisfactorily served the appropriate period as an article clerk. Number 6, true copies of any documentary evidence showing that he is either a federal citizen or a permanent resident of Malaysia. And last but not least, true copies of any documentary evidence that he has passed or is exempted from the BMQE. Continue. Subsection 4 require that the petition, notices, affidavits, certificates to be in the forms prescribed by the board. The forms here refer to Form 1, Form 2, 3, 4, 5, 6, 7, and 8 that we have learned in the previous lecture. For example, for the admission application, the form that need to be used is Form 1 and Form 2. Furthermore, subsection 5 require the petitioner to file his petition at the registrar's office at the central registry accompanied by notices intimating that he has so petitioned, and these notices will be posted at all high courts for the period of 3 months before the petitioner is admitted and enrolled as an advocate and solicitor. So after dealing with the forms, the affidavits, the notices, here comes section 16 on filing of petition and objection. So, under section 16, a copy of each petition and all the particulars needed under section 15 just now must be served to AG, Bar Council, and the State Bar Council. When to be served must be within 7 days of filing in the registrar's office and not less than 10 days or such shorter period as the court may allow before the date fixed for hearing the petition. In case there is an objection by AG, by the Bar Council or State Bar Council, notice of objection must be served to the petitioner and must be filed in the registrar office, stating the grounds for objection, not less than 3 days or any shorter period as the court may allow before the date fixed for hearing. Now, section 17 is on caveat entered against admission. This section is basically saying that a caveat can be entered on the application for the admission as an advocate and solicitor, and it must be entered in the registrar's office. The consequences is there will be no application for the admission of the petitioner shall be heard unless a notice of hearing of not less than 3 days has been served on the person entering caveat. With regard to this section, I would like to bring your attention to this case, Daljit Kaur. This case has been decided in 2019, but it started way back in 2012. What happened was the petitioner has completed her chambering with a law firm. She has obtained a short call order from High Court. She had filed Form 7-8, meaning to say there is no problem with regards to the legal requirement. However, on September 2013, the respondent has filed a notice to enter caveat pursuant to Section 17 of LFP, which objected the admission of the petitioner. And the respondent's ground for filing such notice is that the respondent received reports which indicates that the petitioner at that time was suffering from a disease. So, at that time, the caveat was allowed. In 2019, the court held that the caveat to be set aside because there is a new because basically the report against the petitioner was made in 2013. So after almost 4 years, another medical report from the Ministry of Health indicates that the health condition of the petitioner has improved. So the court in this case held that the situation has changed after 4 years. Therefore, there is no basis and there are no further grounds for the caveat against the petitioner to be sustained. Last but not least, section 14. This section is on filing of admission, petition, and inquiries. This section is basically where the Bar Council shall make or cause to be made full inquiries into the character of the petitioner. But not only Bar Council, State Bar Committee shall, upon the person's petition being set down for hearing, make or cause to be made full inquiries into the character of the petitioner, in which later, if any of these reports turn out to be unfavorable to the petitioner, then the CJ may, if he thinks fit, direct such reports to be filed in court and the copy to be served on the petitioner. One thing to note that all reports and communications on this section shall be absolutely privileged. So this is all for the legal requirements. Now I pass the floor to Fariza.